Yeah, hi, small business owners. It's Harpreet Singh from Sharon Law Firm. So today is our last video about AB5 law. So it's about if you get exempt from AB5 law based on different exemptions, and that means you don't have to follow ABC tests to determine if a particular person is an employee or an independent contractor. So then what you have to follow. So the test comes in, which is called Borella test. It's just originated from a Supreme Court ruling from SG Borella versus Department of Industrial Relation. It's a 1989 case. So this case provided 11 factors, which provides you a roadmap to at least, I think, try to resolve your factual inquiry in terms of if the person is independent contractor or employee. So these factors are different than the ABC test. In a way, the ABC test is much more condensed way of providing the determination if it's employee or independent contractor, and it's also a hard test to meet because any single factor is a determinative thing. But in the Borella test, all these factors, these are just play out in your factual inquiry, and you can just weigh them in based on your situation. So if you're hiring person or the person who have sued you, who is claiming as an employee, if suppose they are able to meet all the tests, all the factors, then sure, means he have a good chance that he or she would be an employee. But if suppose you are not as an employer able to meet one of the factor, again it's not a determinative thing, and it's just again factual inquiry, how much weight should be given to that certain fact which you were not able to meet under this like factor number 9 or factor number 8. So, and also these factors again, so these are not mentioned in some serial wise and gives you more weightage to factor number 1 or 2. So these are like combined factor which provides you the roadmap to at least weigh in different facts and try to resolve your question that if this person is employee or independent contractor. Obviously, if you meet more facts, if you satisfy more factors, then obviously you have a good chance to show either this person is independent contractor or employee. Let's see what are those 11 factors. So the first one, and again, before I think even going to those factors, again I like to touch on the basic theme which all these tests follows. It's about the control and direction of the hiring entity on the hired person. So it's again, if your fact provides that this hiring entity is exerting more control, deciding about schedules, and like treating them as an employee you see in daily life, then obviously it seems to be an employee. so again, it's a factual inquiry. And the theme remains the same, and even you will look in these factors, and also if you remember, you have looked different exemption which can get from AB5 law, which provides and talks about these same factors, and it's again the continuing theme with the Borella test. And the Borella test, it's somewhat relaxed because it's just not one factor determination. It's like several multiple factor weightage you have to look in. So the first factor is whether the worker performs service, hold themselves out as engaged, or they are holding themselves out as business or not. So it's again that thing, if you are a legitimate business, then you are then you should held out yourself as a legitimate business and seek customers, and this hiring entity is not your only one customer. So the second factor is whether the worker is regular or integral part of employer's business. So if suppose, and this situation comes in, when you have some exclusivity contracts. And obviously, exclusivity doesn't also decide that if you are exclusively working for this person, then obviously you are an employee. There can be a different situation because the project is big and you need to spend like your whole 3 months with just only single hiring entity or single homeowner. So that doesn't mean you are the employee of that homeowner or that hiring entity. But still, that would give more weightage if other facts comes in and try to show that it seems to be an employee, this person is coming at a particular place from long time, exclusivity, and then he's not advertising as he's operating as an independent business. He doesn't have an independent office. So like things like that will just add up and just, I think, create more problems for the hired entity, so that the person would be considered as an employee. So let's look at the next factor, and whether the employer or the worker supplies the instrumentality, tools, and places for work. Again, we have discussed this under the exemption of AB5, that if your tools are coming from this hiring entity and all your, I think, things which you need to perform your job, then it again provide more weightage to the resolution of being an employee instead of an independent contractor. It's again just one of the facts which will provide more boost to the argument of person who is claiming as an employee. So the fourth factor is whether the worker has invested in the business. So here, this factor is trying to look at, are you a partner of this business? Because if suppose you are working exclusively and you're getting some kind of a share from the business, usually an employee, other than profit shares, but if you have an hourly employee, usually employees doesn't get the profits of the business. That's the general, I think, knowledge everyone has, because their work is just to perform and get a pay, and they are not acting as a partnership, acting as a partner of a business. So if you are acting as a partner of business, then you are an owner of business. So then the question about if you are an employee, still there can be several different facts which can suggest, even if you are getting certain shares, because usually there are employment situations where you get number of shares, also get profit share, but still it's one of the factor you have to think about. If you're talking about some retail business which only have like one owner, and you are the only so-called, you're claiming yourself as employee, but you are getting 30% of the profits, then that can be, you can weigh those factors based on the other facts you see in the situation. So the next factor is whether the service provided requires a special skill. So it's about if you have an architect working for you, if you have a real estate broker working for you. Real estate broker can obviously work for a builder just alone, just selling their house and conducting those transactions. That can be a situation, but they can also work on their own brokerage on the side and have those other agents and also selling other businesses. That can be also a situation. So it's about the skill. If your skill is more specialized, you are more specialized, then it seems to be, and it's not definite, it seems to be that you have better leverage in the market. So if the other fact supports you, then you are going towards more on the side of independent contractor. Again, the other facts are more important to look the holistic situation. And for example, again, if you are a surgeon or if you are an employee which have certain skills like attorneys. So if you only look this factor, then it seems to be much more going on the on the side of independent contractor if there is not much control or direction. An attorney can just work with other attorneys, and they usually call them as off counsel. That's kind of an independent contractor relationship we have in legal industry. So it depends on those facts, but still, I think if you have some specialized knowledge and the person is working in your business, and you have structured in that way that this person seems to be an independent contractor, then again, those factors I think will provide you more insight into I think determining if this employee or an independent contractor. So next factor is the kind of occupation and whether the work is usually done under a direction of the employer or by a specialist without the supervision. Again, this question comes in about control and direction. So is this kind of a work which you can do on yourself? I think let's see the example of if you have a receptionist. A receptionist, her main work or his main work is usually to make sure that calls are being answered and you are taking notes and providing to your person who have hired you or other people or staff, and you are just coordinating all those appointments. So in that situation, are you able to do your job without any supervision? And I think it would be hard to say for a receptionist, because receptionists need direction about what to do, what to coordinate, which appointments to set at what time. So you can understand, and then you can look on the other side. If you have a specialized person like an architect, like an appraiser, they can take their independent judgment on their own. That doesn't mean they cannot be an employee, and usually big firms have appraisers as their employees, but still it comes the question about this single factor, because that will provide you more direction either to go on the employee side or the independent contractor side. So the next factor is the worker's opportunity for profit and loss depending on their managerial skills. Again, as we have already discussed, and it's somewhat similar, that if you are gaining profits from this business, and if your structure itself that you don't need much supervision, then it's again going to the direction of independent contractor, because you're acting kind of in an ownership status. So we have looked, I think, all these different factors, which provided you some sense that it seems to be like somewhat the same compared to the factors you have looked under different exemptions you have in AB5 law. So it's again the ongoing theme. And the next factor would be the length of time for which services are to be performed. And as you know, if you're an employee, it seems, employees usually they hired at will, but you think that your employment is indefinite, kind of, not in practical side. It's always definite, but you don't have a time frame unless and until you have some contract, but usually you don't have time frame. So the time frame of your work comes into importance, because if suppose you are a builder or some general contractor and you are working on building this particular structure for next 2 months, and then you are out, then it gives you a glimpse that this person is independent contractor because he has only this certain assignment, and then he's moving out. But for an employee has like multiple assignments going on. Generally means facts are always important. So employee has like multiple assignment going on, and they usually are not definite unless and until they are specific in their employment agreement. So from that fact, you can again try to put more weight either on the side of employee or independent contractor. Next factor is the degree of performance of the working relationship. So also I think we have already discussed that the performance part of it, the independent contractor has more control on that side. Independent contractor can, on their independent judgment and discretion, they can perform some task in some different ways, unless and until there are obviously some situation that maybe a building owner can say you, okay, I think it would be risky because there is certain existing risk in that building. That's a different thing. But usually you don't say to the to a builder that, okay, yeah, you should, I think, put maybe rocks at somewhere, or you should put, I think, extra material on that, because you usually basically provide them the map, your vision, and obviously the things you need. But how they perform those things, you don't have much control on that. So usually then the situation comes in and the facts comes in about your performance, and if you have independent judgment in that or not. So those would be, I think, the important factors to look. So again, I think these factors provides you the next factor is the method of payment, whether by time or by the job. And this comes in with your, I think, your general knowledge and also your experience as an employee or owner. Usually employees and lower level employees who are not in the management, they are usually paid through like hours. Because if you need an exemption as a salaried employee from overtime, you would be paying a salary. But again, I think even if you are paying the salary, that shows that, okay, bi-weekly you are paying this much amount. And it's an ongoing thing. But for an independent contractor, if you think, you don't usually pay them like every couple of weeks. You just have a contract with them based on the assignment. And at the end of the assignment or before that, you just have the arrangement of funds, either a deposit, and after that, the completion payment. So based on the payment itself, you can see or give more weightage to either his employee independent contractor. If it's a person who you paid hourly and this person is working from long time. So I think now you're thinking about how I am joining those facts, which we have looked in the previous factor. Because more factors you would be able to meet and try to give the impression that this person is an independent contractor. Obviously that will rule because it's a factual inquiry and this test. One factor is not determinative thing. So the next factor is whether the worker hires their own employees. Again, means it's a very important factor, because usually employees doesn't have their own employees below them. Because either you are working, I think, as an employee alone, or if you are acting as a business, then you have your own, I think, employees. And you would be thinking, yeah, means if you're a manager, then probably you have some people working under you. But still, you are an employee. So employee doesn't usually have their own employees. They can have the colleagues which are working below your role, but you usually don't have employees when you are working as an employee for somebody else, unless and until you are a business owner or have some kind of strange arrangement. So the next factor is whether the employer has a right to fire at will, or whether a termination gave rise to an action for breach of contract. So this is kind of a factor which I think it would be somewhat confusing, because you can have a breach of contract even if you are employee or independent contractor, because you are in contracting relationship. So I think this situation probably comes in when you are working as an independent contractor and your agreement is structured in that way. But one thing you have to understand, again, one factor you have to take in count, how you have structured your independent contractor relationship on the paper and in practice, because it's really important. You cannot, I think, set up your relationship on the paper somewhat differently and then act differently. Those facts will come in when this resolution need to be made. If this person is employee independent contractor, So you have to act similar to what your contract says. Still, there would be several facts which would just put more burden on the employers. But again, I think your contract will try to show, at least I think your contract need to show if that this person is an independent contractor or an employee, because if that's not the case, then I don't know why we are even to that point that the court have to decide that, because you already have into an agreement which probably provide an clear role for this person to be in, so you don't have to even resolve that question. It already seems to be resolved. So you have seen all these factors, and at the end it's the same theme and all the exemptions. But the most important thing, the Borella test, because it's an easy test to meet compared to, it's not actually easy test to meet, but if you compare to the AB5 test, it's easy to meet. And this was the test which was being used from number of years now, before Supreme Court decided to change it in 2018, and then we just see this AB5 law become effective in January of this year. So I think you have got enough information to at least understand the basics of AB5 law and different exemption. So I think if you go to any legal professional, you are, I think, little bit at least prepared to ask some question, or at least even yourself to think about the issue itself about employees and independent contractor, because people don't know, because what they think, usually a lay person, that okay, I have this contract which says he's independent contractor, so why we have an issue, why the state is interfering with our relationship? Unfortunately, the state has passed the law, so you have to follow that law even if you like it or not. Regardless of what you have on the agreement, it would be good if you have that thing on the practice, and if under the law it's designated as independent contractor, then you're good. Otherwise, at least I think you got the good knowledge to at least understand the issue and talk with a legal professional and get prepared with those facts which I have talked about, and think about those things and think about your relationship probably with your present independent contractor in different professions you have, because some professions work on like commission basis, like you are paying this person on commission, and then I think the question again comes in, if this person after the passage of AB5 law, this person is employee or independent contractor, because the issue is that, as we have discussed earlier, that the consequences are great, because if the person, you have been treating him as independent contractor, and if he's an employee, then there is issue about overtime. If the person worked over 8 hours a day and or 40 hours a week, then you have to give overtime. And if the person is working more than 12 hours, or the person is working consecutive 7 days, then the premium pay will come in. And in addition to that, then you have to think about the meal and rest breaks and all the other laws about worker compensation and about the penalties which you have to pay to the state because you have not designated this person as an employee, and you're talking about thousands and thousands of dollars, even hundreds and thousands of dollars, depending on your situation and number of employees. So a single employee can file a lawsuit and they can add a PAGA claim in it that shows that you have misclassified all your other employees. So the consequences would be great at that point. So again, I think I like to thank you for being with this videos, and I know it's too much, I think, stuff which probably you would not able to understand those factors, but at least I think you got structure of the AB5 law and what's the basic I think fuss about AB5, because there is, I think, a lot of talk from last year when it passed, and even before its passage, everybody was running around, especially the industry leaders, that we should be exempt, we should be exempt. But now you have whatever law you have, and I hope there would be some amendments in future as we, I think, develop a case law over this AB5 law, and we get more information about which industry is exempt, which kind of roles are exempt or not, and the professionals which are already mentioned, if their subordinates are exempt from this AB5 test. But again, you have to meet Borella test even if you are exempt. Don't forget that. That doesn't mean if you are exempt from AB5 law, it's done, you win. That's not the case. And thanks for watching these videos. And in the next videos, we will talk about again another interesting topic, or just try to provide you that basic legal information so you can at least get prepared before you meet any legal professional or seek advice about any existing issue you have. Thank you.